Welcome to the Medical Device Made Easy podcast. Here is Munir Lazouzi from easymedicaldevice.com. And today we'll not talk specifically about MDR or IVDR or a specific rule of the regulation. Today I invited an attorney, a lawyer that will help us to understand more about intellectual property. So today we have Stephan Carter, so patent attorney with us. So Stephan, welcome to the Medical Device Made Easy podcast.
Thanks, Munir. It's great to be here.
Great. So thank you for being here. And I hope you will help us because since I'm starting to do consulting, so I had a lot of questions about some specific aspects of the regulation. And some of the questions are more about, for me, I guide people and say, can you please contact more an attorney or a lawyer for that? Because for me, it's more a question of country instead of question of regulation. So I hope you will be able to help us on that. So, but first, can you maybe just make a small introduction of yourself and just tell us who you are, what you are doing exactly, so that people have a better understanding of, how maybe you can help us.
Yeah, sure, I'll do that. So my name, as you said, is Stephan Carter, and I'm the founder of an IP consultancy business called the Intellectual Property Works, which I started just over 3 years ago now, having spent about 23 years working in a couple of different law firms in London. So I've got a long history of helping a range of companies in a range of technology sectors, but with quite a lot of experience in the medical device, digital health space, helping those companies protect their innovation. And now in the new consultancy business, working specifically with the smaller end of the market.
Great. And you are helping mainly in the UK or outside, or also some companies that are maybe outside of Europe?
Yeah, it's a mixture. So focused, I guess, mainly on the UK these days, but helping some other companies elsewhere in the world. So elsewhere in Europe and also in the US, I've got some good contacts and clients there. Okay.
So just maybe a quick question about that before we start with this topic. So did Brexit help you or create more problems for you regarding intellectual property?
It's a good question. And it's an easy one to answer in some ways, because not really is the answer. It didn't really change very much for me personally as a business. And actually, when you look at intellectual property rights, some have changed and some haven't. And patents, which are at the heart of a lot of the work I do, have not changed at all. So there's a European patent, and everyone assumes that's something to do with the EU and would have changed, but it's not. The European patent is separate from the EU and carries on exactly as it was before. So it covers all of the EU countries, but still covers the UK and a number of other non-EU countries. For trademarks and for registered designs, there was a change because there are EU-wide registrations of trademarks and designs, and the UK clearly is now a separate jurisdiction, and you need separate registrations in those countries. So there's a change there, but yeah, if anything for me, it means I now have to file 2 applications for my clients instead of 1. But it doesn't change very much.
Okay, great. So good to know. Okay, so maybe for a start, so one of the first questions, because I think it's the basics in terms of this the topic of today. So we are talking a lot about IP or about intellectual property, but can you help us to define the scope of what are we talking about? What is it exactly that we are talking about? Is it really important or not important to have that? So if you can educate us just on this basic, I think it could be really a great thing for us.
Yeah, I think that's a good place to start, and I'll do my best to educate. I guess I think the starting point for me is that if as a business you're innovating, then you are necessarily creating intellectual property, IP. If you're a medical device business, that IP may come in various different forms. But let's say you're developing a new product that you're going to take to market. There'll be designs of the product itself, both in terms of technical innovation and potentially the way it looks, and that's IP. So the invention, the technical innovation is intellectual property. You'll then maybe developing a new brand name to go with it, and that brand and the brand collateral around that, so the logos and the names and the strap lines, that's all intellectual property. You might have user manuals, you might have an app that goes with it. All of these things that you're creating when you create those things, you're creating intellectual property. And then layered on top of that, you have intellectual property rights, which are the legal rights that you can use to protect that intellectual property. So if you've got technical innovation, you can use patents to protect that technical innovation. If you are developing new brand elements, so names and logos, you can use registered trademarks to give protection to those. And if you developing apps, so software code and other materials, then copyright is a relevant intellectual property right. And so what you typically find is that if in one innovation, or in a business's mind, that they're innovating one thing, they're innovating a new product, but actually what they're doing is they're creating lots of different intellectual property assets that are all tied up in that one product, and then you can use a mosaic or kind of suite of intellectual property rights to offer protection to that.
So do we have some rights that are inherent to the fact that we create that, and rights that we have to activate, if I can say, by registering, like we talked about patents? So do we have those, if I can say, to be careful on this? Because okay, I create a lot of videos, for example, maybe have my copyright in terms of my videos, but I don't have to register somewhere to say that it's my video and it's my copyright or whatever. So, but the patent, apparently we have to put that in a documentation, send that to someone to register the fact that it's our invention and not the invention of somebody else. And usually we are trying to be quick on that, because if someone else is doing the same and is making a patent for this same device, so then we are not not owning anymore these products, or what the innovation we are doing. So is there things that we can say, okay, you don't have to do anything for that, but you have to do something for that?
Yeah, that's exactly right. You describe it very well there. There are each of the intellectual property rights have different requirements and different processes or things you have to do to secure them. But they fall into two main buckets. So you have the registered rights, which tend to be the stronger monopoly rights, which is the patents and the registered designs and the registered trademarks. But then you have the unregistered rights. So things like copyright. You can, in some jurisdictions, you can get unregistered trademark rights just through use of your brand in the marketplace. And there's also in Europe and the UK, there are unregistered design rights, and they come into existence automatically. But the key with those is that if you suspect someone is infringing, the onus is on you to prove that you own this design or this copyright in the first place. So the key tends to be keeping really good records of what you produce when. And you give yourself as a really good example there. So when you create your videos and your other content, because you're the original creator of those, you'll have copyright. And if someone copies those things, you could potentially sue them in court, but you'd have to demonstrate that you were the original creator and that you therefore had the copyright.
Yeah.
Record keeping is key. But
and I hope the fact that I'm on the video shows that.
It probably helps. Yeah.
Exactly, it probably helps.
Yeah.
So one thing that why I invited you maybe for this podcast is mainly because, as I say, I got a lot of questions about medical device companies that are maybe making some confusion between regulation in terms of certification of products, the rights to register a product in a certain country to be able to sell it, and the other part, which is intellectual property, brand names, design, as we talked about. So one of the, if I can say, one of the area, one of the topic that comes most of the time is the one we are calling OEM OBL, so original equipment manufacturer, own brand labeling, which is a state where we have a company located maybe outside like China or USA or Brazil or wherever, that is manufacturing a product without a brand, so just manufacturing a product. And then some companies are buying those products and putting their brands on it and then saying it's my product and I sell that as my product with my brand on it. And then we have this situation now with the new medical device regulation that we are saying this is not possible anymore to do this activity without being the if I can say, the fully responsible person for this product. So it's not that to say, I am not the manufacturer, I'm just here to sell the product with my brand name, but the manufacturing is done by this company. So I'm completely out of that. Now it says, no, you have to be, or you are fully responsible for it in terms of manufacturing and being the responsible, or you are just distributing something that another company is doing. So there is those two options. And one of the options is to say, okay, I am the distributor now. I don't want to be the fully responsible person of that thing. I want to be the distributor. So I will buy this product again. I will just make an agreement with this company to put my brand on it, but they will remain the full responsible of this product. But it's my brand, it's my name on it. So here there are a lot of questions saying, okay, what about IP? What about copyright? What about trademark? What about all those things? So who owns what? Who has the right to do what? How can we protect our company out of that? So can you help us on this kind of thing?
Yeah. Let me try and give some thoughts on that, because it's an interesting situation, and it's probably the way to look at it is to go back to basics, and it touches on one of the points I made earlier, which is that when you look at one product in the marketplace, there could be various different intellectual property assets kind of wrapped up in that product, and it's also possible that the different intellectual property assets in that product are owned by different people. And the questions around ownership of intellectual property are often the trickiest ones. They're often the things that trip people up when it comes to due diligence in corporate transactions, because they're easy to not think about. And you know, they sit there like a ticking time bomb, and then they come and explode in your face when investors ask awkward questions. But taking the specific situation, so if you have a product, let's think of maybe a slightly more complicated one. So you might have a product that's designed and engineered by one organization.
Yeah.
So they've come up with a design, which means the starting point is they will own the technical innovation, the invention in there. And that may then be manufactured by another entity. So maybe your Chinese manufacturer or your Brazilian manufacturer, as you say. And they may have some intellectual property tied up in the manufacturing process. Maybe they're the ones that have worked out how to produce the product at scale. So there could be some new innovation there. And then your distributor in the country where the product's going to be sold, in your example, they're applying their logo, their brand to the packaging. Maybe the packaging they're having made somewhere else, but that their intellectual property is the intellectual property that's in the brand. So they may have registered trademarks, they may have copyright in the logo. So when you look at the product as a whole, there might be in that scenario there might be three owners of the intellectual property in that ultimate product.
Yeah.
And the key for the distributor who's selling the product is to make sure that they have all the rights that they need to be able to sell that product without getting into trouble. And that's normally achieved through appropriate agreements, so licensing arrangements. So, the design company that came up with the original design would probably license the manufacturer and license the distributor. And so license their intellectual property, and then the manufacturer can license their intellectual property to the distributor as well, to the extent they need to allow the distributor to sell. And then the distributor has their own intellectual property in the brand. And if they're then selling that on, maybe they're a main distributor and they're selling it on to other organizations to then sell to the end user. They would probably want to have agreements with those smaller distributors to make sure that they couldn't abuse the brand of the distributor.
Yeah, so it looks like there is, if I can say, many levels, or a sandwich with a lot of layers here, where everyone owns something, and at the end we give the authorization to the next level, if I can say, of the sandwich, to say you have the right to use my design, you have the right to use my product that I manufacture, you have the right to use my brand or this and that, etc., etc. So at the end, here, for example, if we are a distributor and we have this brand name that we are using to sell our products, and if there is a big issue in terms of the design or in terms of the manufacturing of the product, at the end, the impact is more on the brand, I suppose, because this is the brand that choose to make these products available also on the market. So is this something that it's something that maybe also is a problem for those companies to say, I will buy a product from a third party, but I will put my name on it, but maybe there is also a risk for me to have some damages on that. So is there also some agreements to have in terms of that, to say, oh, if there is an issue on the market, you have to help me in terms of this, or you have to do that, or the license is just, no, I give you the right to use it, but at the end you have no authorization to do anything else with that. So is there some rules here?
Yeah, I mean, so yes, there are, in the sense that, so the license of the intellectual property is normally just one part of an overall agreement that will be, the agreement between the manufacturer and the distributor, which covers a whole load of things, like how much the distributor is going to pay the manufacturer for the product, what territories they're allowed to distribute in. But within that agreement, you can place responsibilities on the different parties. So, I mean, clearly, you're right. When the distributor is selling a product, in the eyes of the customer, they're the ones they're going to blame if something goes wrong. And so there's a risk. You take on that risk to a degree when you become a distributor that wants to distribute under your own brand and build your brand and build the value in that brand. But you can build safeguards into the agreement. I guess firstly, you make sure you pick a reputable supplier in the first place who you think is going to produce a quality product. And you make sure they have the right, which you wouldn't necessarily have in the medical device space. You make sure they've got the right quality controls in place. And you might have provisions in the, depending on the relevant strengths of the parties, you might have provisions that allow you to have some oversight of that quality control. And then you might also have provisions in the agreement that if something does go wrong with the manufacturer, of the product, then the manufacturer is at least financially liable. So, if you get into trouble and you get sued by your clients, you can turn to the manufacturer and say, well, you've got to cover the cost of this. But that doesn't necessarily help with the reputational side of things. The reputational side of things is all about really making sure that the quality is there and that you have some kind of control over that quality.
No, I think it's clear, and it's something that is really important. As we said, the quality management system with really something that is preparing you for any kind of situation is really, really important. So here in terms of the product, so there is also one case, and you talked about that. So where those products can be distributed. Can we have the situation where a manufacturer that sees maybe that one of the distributor is doing really well with this product, so he's making really some money with that, and say, okay, they have maybe distribution in Europe, but I want to distribute that in Russia or in Australia or somewhere else, and I will put this brand name because this brand name is not registered in Australia or somewhere else. So can I steal their brand name and register that in another country like Australia and say, oh, it's exactly the same product as what we are selling in Europe, so it's the same?
Yeah, it's a great question, and I guess the starting point is that if let's say the parties were totally unrelated, so I have the mark, or so you have the mark. Easy Medical Device registered in Europe.
Yeah.
And I think that's a great brand. I'm going to set up a podcast in the US.
Yeah.
And I'm going to call it Easy Medical Device. From a registered trademark point of view, if you might have a registration in Europe, but if you don't have a registration in the United States, then you don't have any registered rights that you can use to prevent me from doing that.
Okay.
So that's kind of the starting point, quite simple. Yeah. Because these registered rights they're national or they're regional rights. So if you want protection, if you wanted protection all around the world, you'd have to spend, a ridiculously large amount of money on getting trademark protection in all of those countries. And no one ever does that. People typically will seek protection in what are the main markets, the key markets for them and their products or services, as a way of managing budget for that. Now, in some countries, you have these unregistered trademark rights. So you can, if you build up a reputation in a country, even though you don't have your trademark registered, then there might be action you can take to stop someone, because the argument is that that they're creating confusion. They're making the public think that the goods they're providing, the products they're providing, or the services come from you, when actually they're not, and they're not associated. So sometimes there are other actions you can take, but it generally relies on you having a reputation in that marketplace, so people are confused.
But can you also block that just by putting that on the agreement to say you are not authorized to do that?
Yeah, so that was the point I was going to come to. So that was, we started off saying if the parties are totally unrelated, then that's kind of the situation. When you've got an arrangement where there's an agreement between the parties, then yes, you can place more restrictions than the basic law would provide on them. So, if you look at it the other way around, the manufacturer of the product can certainly restrict the distributor to distribute only in a particular jurisdiction. Now, there are some sort of rules around that. So you couldn't, it's harder to carve up the European Union, for example, because there's free movement of goods within the European Union. So once a product has legitimately gone on the market in the European Union, you can't really stop it moving, being sold into other countries within the European Union. Okay, but you can carve things up in that way, geographically, or even kind of sector-wise. You can carve things up. With the looking at it the other way, if you have a manufacturer who starts using your brand, it's a bit trickier to tie that up in an agreement, but you can certainly try. So you can. So particularly if they are printing the logo onto the packaging for you, which may well be the case. If they're manufacturing a packaging, you would have a license of your intellectual property to them, and that license could have the restrictions in that say, you must only use this logo on packaging for product that you are going to send to us to distribute. And so they would be in breach of that agreement if they then used that logo on other packaging. So you have an action you can take against them then.
Right. I think it's exactly that, because more and more we talk, more and more I hear that the agreement or the contract that you are signing should be really well written, with all those cases that we discussed today, that should be inside, with the clauses, with all those things. And I'm always a bit sorry for the people that are contacting me, because they are asking me, they think really that we are here talking about regulation like CE certification, regulation like MDR and whatever, but it's not part of it, if I can say. It's why I'm always trying to say, contact a lawyer, because I think this is something that is really something that a lawyer can really help you with, and can provide you really all the information that you need to have on your documentation, or the cases that can happen, and that you can protect yourself with that. But I think, it provides us really a lot of information here about that. One thing that also I get asked, and maybe you can help us on that, is the fact that as we said, so those products are sometimes manufactured outside of Europe, for example, as we said, China, USA, or Brazil, or Africa, or wherever. And we get them, we buy them as is. So there is no kind of difference. We buy them as is, and then we place our name on it, and we are the legal manufacturer this time. So we are not distributing that with somebody else legal manufacturer. We say, no, we are the legal manufacturer. We just buy the products. We create the technical documentation. We create the CE marking. We get the certification for it, etc. And we have our logo on it, and we distribute that. The question that I'm asked always is, can I put also, for example, I'm located in France. Can I put also made in France, or I'm located in Germany and put made in Germany, because maybe in Germany it's like a quality country. We really see that as a quality country with the good cars and whatever, and say, if it's coming from, if it says made in Germany, it will be a good brand, when at the end it was not manufactured at all in Germany. So is there a rule here on how we can place this made in Germany, France, or whatever?
It's a good question, and I can see why distributors in particular countries would want to be able to say that. I guess I guess the first one is that it's not really specifically an IP question, but I guess the underlying principle is probably you have to be truthful. You can't say something's made in a country if it's not. But then you get into the interesting question of, well, what does manufacturing mean?
Yeah.
And I think, I'm probably no expert on this, but it would seem to me that, if all you're doing is taking a product and yes, you've taken on responsibility and you've taken on liability for the quality of the manufacturing and you've got risk there. But if the product was still manufactured in Brazil, let's say, and all you're doing is putting it in a box in France or putting it in a box in Germany, I think I don't think it would be truthful to say that was manufactured in France or manufactured in Germany. If you're taking components that have been manufactured elsewhere and you're assembling them in France, then, arguably it's then more truthful to say it's manufactured in France.
Yeah, I agree.
And it'll be one of those things where, there'll be, so in the UK, sort of trading standards and some of the other sort of government or regulatory type bodies will have views on when you can and can't say manufactured in a certain country. And I think it'll be one of those things where there's a lack of harmonization and you probably have to ask the question, country by country almost. I think it's, but my best advice from a non-expert perspective would just be truthful.
Yeah, no, I agree. I know in some countries, I don't know, I don't have a list, but in some countries, it's like if you are doing a certain percentage of the activities, like you mentioned, if you are receiving some components and you are assembling them to create the equipment at the end, so then it's maybe you can say made in, because it's like more than 70% of the things that are done within your activity, which is assembling, controlling, packaging, cleaning if it need a cleaning, etc. All those things, and putting the label on it, etc. And then storing that. So mainly, which is like more than 70% instead of just receiving a component. But yeah, when you receive the full package with all the product inside that is already finished, and you have, and maybe you are not controlling at all, you just receive the box and you sell, you distribute that immediately. Then there is not really any made in activity done in the country. So it's more something to do. But I agree with you. It's also what I'm saying. Please go to a lawyer in the country where you are trying to distribute, or where you are trying to make the made in Germany or France or wherever, so that you have really the legislation in that country. Because it can maybe be easier in one country than the other to put the made in the country name. So. Okay, so I think it's really interesting here, because I like really the fact that we have somebody that is not really a medical device expert, but is already a lawyer or attorney in a certain area that is linked to medical devices, because it helps us also to see the perspective outside of our business here. So maybe if I can say so. What can you do for people? So which people can help you or can contact you for which kind of cases? What kind of service you can offer to them, so that maybe you get some people out of this podcast that get out to you?
Yeah, let me also talk a bit about what I do briefly. I mean, so I guess the sort of businesses that I can be most helpful to are businesses who are developing their own products, innovating, so designing their own products. And they probably recognise that intellectual property is something that could be important to their business, but it's a complex space, and a lot of small businesses don't understand exactly how it fits into their processes and their business. And so one of the starting point for me, often working with a new client, is I'll do an IP audit. I refer to it as. So it's kind of I'll get into the business, understand what they do, understand how they make money, how they plan to make money, understand how their product has been developed or how they're planning to develop their products. So we can work out what IP is being generated, what the best ways of protecting that are. Because, and sometimes the answer might be that actually, you don't need to take steps to protect it, or actually the best protection you can get is by keeping the IP secret. So using trade secrets to, the classic example of that everyone gives is the Coca-Cola recipe, or the KFC recipe is another good one. Yeah. Whereas if you try and patent those developments, then part of the patent process requires publication of a lot of detail about what it is you're doing. And once you've published that detail, yes, you've hopefully got your patent to have a monopoly, but that's limited in time. That's 20 years maximum for patent protection. Whereas if you can keep something secret, you can keep it secret forever. So, sometimes having done all that investigation, the right answer is keep it all secret, or keep some of it secret and patent some other bits, or make sure you've got your brand protected. But it's that kind of audit to say, right, let's look at your world, let's look at your business, and let's see how you can best protect that value that you're generating. Because ultimately that's what investors, for example, are going to be interested in. They want to know that if they're going to be pumping money into your company so that you can take these amazing products to market, that they've got some chance of getting a good return, because you're going to have that exclusivity and you're going to be able to protect that IP that you've been generating.
I think it's good, and as you said, I think it's really important. Not in terms of, it can be also linked to that too, in terms of quality of products, but more in terms of protection of your company, protection of your business, protection of what you are doing. And I like the fact that you say, keep secret things can be also an option, because it's true that as long as you are not disclosing anything. So if you have a good safe, if you have a good protection, that maybe just keep the recipe inside this safe, and that is fine. So it can be one of the options. But it's good to have some expert that can really help you on this kind of thing and help on that. So don't hesitate to call Stephan for that. So Stephan, where people can follow up with you? Are you on LinkedIn or this kind of thing?
Yeah, so I'm quite active on LinkedIn. That's probably one of the best places to follow up with me on. If people have questions, always happy to jump on a chat and answer questions for people, or email as well.
Okay, so I will put that on the show notes. So do you have a website also for your company?
Yes, I have a website, and Twitter is another way of contacting me. So
okay, so I will place all those links on the show notes. So please, for those that are listening, so just go on the show notes of the episode, and you will get all the information. If you want to contact Stephan just to get maybe some advice, or if you want to hire him for helping you on your intellectual property, I think you've seen during this episode that we have discussed a lot of things related to some cases for medical devices, but maybe you have your own cases that you can discuss directly with Stephan. Okay, Stephan, so it was really a pleasure to have you on this episode, and I hope maybe if we have another topic, I will try to contact you again and see if you can help us on that. But it was really a pleasure, and I wish you really a nice day.
That's great. Thank you, Minette. I really enjoyed it.
Bye-bye.
Bye.